Is Ripple truly secure, as the SEC claims, or is this merely a government attempt to stifle a thriving, highly potent cryptocurrency that truly has the potential to rule over the economy and wreak havoc on the centralized currency? Keep an eye on. Learn more about the issue at hand and why the SEC is so strict on it. Obtaining Ripple to be designated as security. We will go over the most recent developments in the case. In addition, hello, XRP Army. I'm delighted you can join us today, and welcome to the Millionaire Mindset, your one-stop shop for all things XRP. Make certain to like and subscribe so that we can provide you with more XRP content. Let's get to work. Understand that cryptocurrency prices fluctuate frequently, so by the time you watch this video, it may have changed completely. Value. After conducting your own research, you should make all financial decisions. The court recently dismissed the SEC's request for access to the documents, which recorded the conversation between Ripple and the attorney in order to determine if they shared any information on the defaulted transactions as it was. This motion was dismissed. It is not proper for the court to allow a breach of the attorney-client privilege that may occur, even jeopardize fundamental legal principles as a result of the court's rejection of this submission. People saw this as a significant step towards Ripple's victory. Since that time, the case has now progressed to a new phase. One of the major issues that Ripple faces has been pointing out was the SEC's lack of notice informing Ripple that it will be declared as a security measure. They claim that no such notice was ever issued. Therefore, any such action taken without reasonable notice must be considered arbitrary and is not in accordance with the law. With regard to the fundamental principles of justice, such sanctions against cryptocurrency were not enacted due to the lack of required notice to the company. The SEC, on the other hand, reports that adequate notice was provided to the it will be declared as a security by the company. They assert that the notice stating the same is false has been made available at all times, and they also claimed that such allegations of not being given adequate notice cannot be admitted as completely false. Lately, according to the company's most recent filings, Ripple is asking the court to disregard Cornerstone Research's report and, as a result, reject the SEC's request to take judicial notice of the situation. The SEC's claim here was to take the report. Cornerstone Research published it as evidence without the need for proof. This was obviously the case against anything Ripple could ever want, and as a result, Ripple declared their intentions regarding the being referred to research. The private research report aims to produce around 70+ results. Enforcements for these cryptocurrency companies that may pose a broader threat, being a report written by a private company, as well as requesting that it be accepted as a piece. The SEC's assertion of evidence without proof is yet another abrupt claim. Demonstrates the desperate attempts made by the same to establish its beliefs and to maintain its actions. The SEC then requests that the court take judicial notice of the efforts by a private company to smuggle in cases numbering more than 70, which may have a high monetary value. Furthermore, the SEC's failure to speak or mention anything about such an allegation at any time during any other pleading, and, most importantly, this argument was completely novel, and admitting it as such was once again a question. That was something that needed to be taken seriously. The Ripple attorney's opinions are based on these findings. They wrote and stated their intentions. These allegations leveled against Ripple, according to Ripple's attorneys, appear to be deceptive and are limited to taking. The court took a different path to prove the case in an absurd way. These inquiries. According to Ripple's attorneys, it was extremely premature to make a request to the making a decision or concluding a case based on such a document was not something the court did. That may or may not be permitted by the court. The assertion made by market participants had a fair warning about XRP being classified as a security, while the company itself was once again regarded as a mistake by them and demonstrated the manner in which the SEC misled the court throughout the proceedings, being one of the very first cases filed against a corporation and the individuals within the company in charge of selling and distributing a well-known digital asset. It was critical for the SEC to be more vigilant in accordance with Section 5 of the Securities Act. Critical and analytical, with no ambiguous claims that are not legally binding. Them. Ripple's attorneys have always made certain that they assert and bring forth their claims. The fact that there has never been any kind of notice opposing the SEC's claims. Even if the SEC were to rely on a report issued by a private company claiming more than 70 companies have been found to be in violation of certain legal provisions, with approximately 37 of them speaking out concerning the defaults carried out by those selling unregistered stock rather than digital assets. The report does not apply to Ripple because they do not sell stocks in any way. It becomes inapplicable to them and, as a result, greatly misleads the course. The reports that have been provided are only intended to highlight a specific aspect that, in fact, exists. Has nothing to do with reality. The attorneys for Ripple provided these perspectives. Who could not who have been dissatisfied with the steps that the SEC has taken in. Most recently, the attorneys went on to say that, despite the SEC's claims, have warned the market about ICOs, and it also claimed that two other well-known coins, Bitcoin and Ethereum, for example, were not securities. The attorneys continued with this point in mind. To determine that the SEC is only holding the violation of Section 5 in the context of the ICOs, and not for well-known assets such as Bitcoin and Ethereum, the chances. It was also difficult for any reasonable person to believe that XRP was not secure. Regardless. Because this was the case, the SEC decided not to investigate the reasoning and to proceed with the investigation. Allegations. The SEC's attempts to bring in the two defendants, Garlinghouse and Larson, into the case for aiding and abetting Ripple's violations, and thus being the reason for this to have occurred, was proof of the SEC's intentions. Have been since the beginning. The entire case has had a significant impact on the coin. As it was removed from some platforms in the United States, we will, however, continue. This coin is performing well in Asian countries, particularly Japan. Since the issue of not receiving such notice had been raised several times. Several times, the SEC appeared to clarify that such claims are false. In addition to this, the SEC's attorney claimed that they could not legitimately claim a lack of notice in any way. As a result, the same digital asset will include security. As a result, they filed a large number of actions they had taken in the past, including the sale of digital assets. As of June 7, the SEC had requested that the court grant it a few more days to respond. In response to Ripple's request that the SEC make public its internal communications regarding other coins available on the market, this will assist Ripple in determining the unjust actions being taken against them, as well as being critical in analyzing the impact of the other coins in circulation. In the case at hand, these internal communications have been extremely beneficial. Utmost importance because they will reveal one of the most important aspects of truth. In the present instance, for the same reason, this subject has been discussed since December of last year, despite the fact that the case has slowed progress. Despite the fact that many American platforms have delisted this coin, it has still been able to maintain its position as the seventh largest cryptocurrency in terms of market capitalization. As the battle for internal information and communication continues, with both parties attempting to get into the internal records because they will be crucial in determining the outcome of this case. The SEC has already attempted to extend the deadline by 60 days. Yet to be determined, the SEC has consistently highlighted Ripple's failures. SEC has been displaying for a long time. However, a possible breakout for SEC has not occurred. Not yet been noticed. The likelihood of the decision going in Ripple's favor is high. There are a number of websites that have even begun sending email alerts to those who have expressed an interest. I'd like to get into it as soon as it's released from the lawsuit. This will result in a massive. As soon as we see the case coming to an end, we will see a breakout to the upper sides. Let us know in the comments if you're fed up with the SEC's lawsuit and want Ripple to drop it. Already, you have won the case. Make sure to follow the channel. Take care, Kings, and see you later.